Hello, this is a representation of a webinar previously given on June 4th on the topic of Paycheck Protection Program, PPP Loan Forgiveness, Guidance for Small Businesses. This representation takes into account changes made to the program under the PPP Flexibility Act of 2020. My name is Richard Grossman. I'm an attorney at Debevoise Plimpton, and I'm joined by my colleague, Jason Samston. Forward slide, please. In the original presentation, a representative of the Neighborhood Entrepreneur Law Project gave it welcoming remarks and an overview of the project's COVID-19 clinic, which remains open and available to those small businesses in need of legal advice. We'll spend just a few moments with these slides up before we proceed to the presentation. This presentation provides a general overview of the process to apply for PPP loan forgiveness based on currently available information. Just a few notes and disclaimers. We won't be able to cover every aspect of loan forgiveness, but our intent is to cover topics that we anticipate being relevant to many small business owners. In the course of our presentation, we'll address as many of the questions submitted in advance as we're able. However, this presentation is not intended to provide individualized legal advice. Participation in this presentation does not create an attorney-client relationship between us, and we can not advise you about your particular PPP forgiveness application in this forum. Next slide, please. Since the PPP program was created by Congress back in March, the Small Business Administration has been issuing FAQs, rules, and guidance, providing clarifications and sometimes new rules and requirements. Importantly, the PPP Flexibility Act of 2020, which was signed into law on June 5th, made further, generally borrower-friendly changes to the program. We've noted many of the key changes in this presentation. However, other topics covered in this presentation may also be affected by updated regulations implementing the new bill, which continue to come out. Therefore, it is important that you regularly check the SBA website for updates to make sure your forgiveness application is consistent with the latest rules and program requirements. So for purposes of this presentation, we've assumed that our listeners have already applied for and received PPP loans and are preparing to apply for forgiveness. So initially, when would you submit your application for forgiveness? The application can be submitted at any time on or before the maturity date of the loan, including, as most recently clarified by the SBA, even before the end of the covered period, once all the loan proceeds have been used for eligible purposes. But if you apply prior to the end of your covered period, and we'll discuss the covered periods in a moment, you would factor in any reductions based on the full covered period. And again, we'll touch on those reductions in later slides. Most borrowers will likely elect to apply after the end of their covered period. And by covered period, we mean the earlier 24 weeks or December 31, 2020, or if you elect, you may use an 8-week covered period from the date that loan proceeds were dispersed to you. If you have not submitted an application for forgiveness within 10 months after the end of the 24-week covered period, the loan is no longer in deferral and interest and principal payments will become due. How to apply. You'll apply for forgiveness through the lender that made your PPP loan or that's servicing your PPP loan. Borrowers will use Loan Forgiveness Application SBA Form 3508, which is available on the SBA website, along with supplemental forms and instructions. There's a link in the presentation slides to the SBA's website. Your lender may also ask you to use their own electronic application form, which will be based on the SBA form. After you submit your application, the lender has 60 days to approve or reject in full or in part the application and to report to you the forgiveness amount. If the approved forgiveness amount is less than the amount that you requested, you'll have 30 days to request the SBA review of the lender's decision. And any amount not forgiven must be repaid on the 2-year loan schedule along with interest. That said, loans that are made after June 5th automatically have a 5-year maturity date, and borrowers are permitted to negotiate a longer maturity period than the original 2 years with their lenders, again, up to 5 years. Next slide, please. In connection with the PPP Flexibility Act and in an effort to make the program more user-friendly, especially for smaller borrowers, the SBA has introduced a short form loan forgiveness application known as SBA Form 3508 EZ, and it can be used by any borrower that meets one of the following criteria. It can be used by self-employed individuals, independent contractors, or sole proprietors who had no employees at the time of their PPP loan application and did not include any employee salaries in their payroll computation when they applied for the loan. Or it can be used by borrowers who did not reduce annual salary or hourly wages of any employee by more than 25% during the covered period. More on that later in the presentation. And also did not reduce the number of employees or the average paid hours of employees between January 1, 2020 and the end of their covered period. For this purpose, you ignore reductions where the borrower was unable to rehire similarly qualified employees for unfilled positions on or before December 31, 2020. You'll also ignore reductions in an employee's hours that the borrower offered to restore and that the employee refused. Or the third category is borrowers who, again, did not reduce annual salary or hourly wages of any employees by more than 25% during the covered period, and were unable to return to the same level of business activity due to compliance with federal requirements or guidance regarding COVID protections. Calculating the forgiveness amount, there are two broad categories of costs that are eligible for forgiveness under the PPP program. The first are payroll costs, and we'll get into what payroll costs include in a moment. Importantly, under the PPP Flexibility Act, payroll costs must be at least 60% of the forgiveness amount requested. According to SBA regulations, borrowers who do not use 60% of the loan for payroll costs are still eligible for partial forgiveness, but payroll costs must be at least 60% of the total forgiveness amount. Just to be clear, no problem if you use more than 60% and even all of your PPP loan proceeds for eligible payroll costs. That would be in that situation, the borrower could receive full forgiveness. Non-payroll costs, again, are permitted to be up to 40% of the loan forgiveness amount, but those non-payroll costs must fall into specific categories. The first is either rent or mortgage interest under real property or personal property leases or mortgages. And again, for mortgages, that's interest, not payment of principal. And the other category is utilities, which includes electricity, gas, water, transportation, telephone, and internet access. Importantly, the lease, the mortgage, or the utility agreements in question must have been in place before February 15th, 2020 for those payments to be eligible for forgiveness. And the costs, whether payroll costs or non-payroll costs, must be incurred or paid during the covered period, or in the case of payroll costs, the alternative covered period, which will be discussed shortly. Next slide, please.
Hello, everyone. Now we're going to discuss some of the details in calculating your PPP forgiveness amount and in any reductions that may be applicable. So first, we're going to talk about what constitutes what's included in payroll costs. Payroll costs are include a pretty broad array of expenses that would be paid: salaries, wages, commissions, or similar compensation. They include cash tips or equivalents, and we'll get into that a little bit later as to how to calculate cash tips. It also would include payment for vacation, parental, family, or medical sick leave. In addition, they would include any payments that are made for the allowance of separation or dismissal from employment, as well as any payments for the provision of certain employee benefits, including employer payments towards group health care coverage, insurance premiums, and retirement contributions, and the payment of state and local taxes assessed on employees' compensation. Compensation includes all cash compensation, including hazard and bonus pay. So that is one way to supplement payroll and increase your payroll costs if that will help you in your forgiveness calculations. Importantly, it also includes salaries that are paid to furloughed employees. I believe this is a question we received prior to this presentation. So it does include employees, even if they are not working, so long as you continue to pay your employees. For the purposes of calculating tips, one would rely on past records of what tips have generally been, or if those are not available, you can make a good faith estimate of what the tips would have been during the period. Importantly, there's a cap of 100K annual cash compensation per employee. So you cannot include in payroll costs any employee that's making over that amount. Also importantly, it excludes any payments to independent contractors, because independent contractors can apply on their own for a PPP loan and PPP forgiveness. Payroll costs are incurred on the day the employee works or would have worked and must be paid on the next scheduled payroll date. So what that means is that if you have a payroll date that is later than the end of your current period, you can still include in your payroll costs the remaining days from your previous payroll date to the next payroll date that are included in the current period as part of your payroll costs, as payroll costs that were incurred. And the same would apply for non-payroll costs as well. So for independent contractors or sole proprietors or owner employees, there's some different rules. Payroll costs include wages, commissions, income, or net earnings from self-employment or similar compensation. But importantly, owner employees and self-employed individuals can be forgiven for, are limited in their amounts they can be forgiven for depending on their current period. As we'll talk about in a bit, PPP loan borrowers who received a loan prior to June 5th can opt to keep the 8-week period. And if you choose to do so, then the owner, employee, and self-employed individuals would be capped at the lesser of 8/52, or approximately 15.38% of your 2019 compensation, or $15,385 per individual in total across all businesses. If you do not opt to use an 8-week period or you applied after June 5th, you have a 24-week covered period. And then for the purposes of owner compensation, it is capped at the lesser of 2.5 months worth of 2019 compensation. And that will be calculated again, multiplying against 2.5 over 12, or 20,833 per individual in total across all businesses. So as I just mentioned, the cover period under the PPP Flexibility Act was expanded from 8 weeks to 24 weeks. Importantly, it gives borrowers who received the loan before June 5th the opportunity to keep their 8-week period, in which case you would still calculate your cover period based on a 56-day period rather than a 24-week period. Your cover period begins on the date that you receive your loan proceeds, unless you opt to use what the SBA refers to as your alternative payroll cover period. And this alternative cover period, it provides flexibility if you have a payroll that is biweekly or more frequent, and the payroll date is later than the date that you receive your loan proceeds. You can begin counting your payroll cover period from the first day of your pay period. So for instance, if you received your PPP loan proceeds on Monday, April 20th, and the first day of your first pay period is Sunday, April 26th, 6 days later, the first day of your alternative payroll cover period would be April 26th, and the last day of the alternative payroll cover period, assuming a 24-week period, would be Saturday, October 10th. And importantly, this alternative payroll cover period only applies to payroll costs. Non-payroll costs must still be incurred or paid during the traditional cover period, which begins on the date you receive loan proceeds. Now we're going to talk about 2 important reductions that apply to your PPP forgiveness amount. The first pertains to calculating any reductions that are related to reductions in salary. The amount of your loan forgiveness will be reduced on a dollar-for-dollar basis for any reductions in salary or wages in excess of 25% of the employee's salary or wages between January 1st, 2020 and March 31st, 2020. Importantly, this reduction is calculated on a per employee basis, not in the aggregate, and it excludes any employee who made more than $100,000 in 2019. The reduction does not apply to employee salary and wages that are attributable to a monthly FTE reduction, which is the second important reduction that we will discuss in a few minutes. So if the reduction in salary is attributable to a reduction in hours or monthly FTEs, you will not be penalized twice for the same reductions. Now, an employer can cure any reductions in salaries by eliminating that reduction in salary and wages by December 31st, 2020. Just to make this a little bit more concrete, for instance, if you were using a 24-week covered period and your previous weekly salary for a particular employee was $1,000 per week, and now there's a reduction in that salary during the cover period in which the employee is paid $700 per week, the first $250 of that reduction will not lead to a reduction in your PPP forgiveness, but the remaining $50 multiplied against the 24 weeks would be calculated and included as a reduction in your PPP forgiveness amount on a per employee basis. Now we're going to talk about the second important reduction, which is a full-time equivalent employees reduction. And the amount of your loan forgiveness will be reduced if the number of full-time employee equivalents at your business went down. Importantly, FTE is not headcount. It refers to the number of hours that a full-time employee would be expected to work during the covered period. The SBA considers a full-time equivalent employee to be an employee who works for 40 hours a week. So in calculating FTEs, you have two choices. You can either consider any employee who worked less than 40 hours a week as a 0.5 FTE, or you can calculate FTEs based on the hours worked for each employee. And the way that this would be done is you divide the average number of hours worked for each employee per week by 40, capping the quotient at 1. So for instance, if an employee works 10 hours per week, his FTE will be 0.25 for that period. So in calculating the FTE, you first have to choose a reference period. Most borrowers can choose between a reference period of February 15, 2019 through June 30th, 2019, or January 1st, 2020 to February 29th, 2020. Seasonal businesses can choose between those two prior periods or a different period. In calculating your FTE during the then you first calculate your FTEs during this reference period. Then you'd calculate your average FTEs during the comparison period. Then you'd calculate your expected average FTE during the covered period. And as a reminder, this could be an 8-week period for those who applied before June 5th, if you elect to do so. And now when you compare your two FTE counts, if your FTE has gone down, you could consider rehiring employees or increasing hours to avoid reducing forgiveness amounts. And this is because there is a safe harbor if FTEs went down between February 15th and April 26th, 2020, but they go back up by December 31st, 2020, then there is no reduction in forgiveness amount that pertains to the reduction in FTEs. Importantly, there's a few other safe harbors from the FTE reduction calculation. Firstly, if you had a reduction in employees' hours, but you then make a good faith offer in writing to restore the reduced hours of an employee on the same terms, and the employee declines, and you maintain proper records documenting the offer and rejection, then you do not need to count that position as a reduction in FTEs. In addition, there's another safe harbor if forgiveness that's related to employees who were fired for cause, were voluntarily resigned, or voluntarily requested a reduced schedule. In addition, the PPP Flexibility Act included an important new safe harbor from the FTE Reduction Exemption. Under this exemption, the forgivable amount would be determined without regard to a reduction in FTEs if you can, in good faith, document that you were unable to rehire former employees. These are employees that were employees of the company as of February 15th, and are unable to hire similarly qualified employees for those unfilled positions on or before December 31st, 2020. You are required to report the rejected rehire to the State Unemployment Insurance Office within 30 days if you would like to take advantage of this safe harbor. The second safe harbor under this exemption is for those who are able to show that they were unable to return to the same level of business activity due to compliance with federal requirements or guidance related to COVID-19. In order to take advantage of this exemption, you'd have to certify that the reduction in business activity during the covered period stems directly or indirectly from such compliance. Importantly, SBA guidance has indicated that this does not only include federal requirements, but also includes local government shutdown orders that reference federal guidance. So for instance, as an example provided by the SBA, if you are a beauty products, are in the business of selling beauty products, and you normally do so both online and in a physical store, then, and your physical stores were closed due to a local shutdown order, you would qualify for this exemption that would lead to a safe harbor from any FTE reductions calculations. Importantly, in order to take advantage of the safe harbor, you also need to provide supporting documentation, which would be the applicable COVID-19 guidance, which led to your business activity being reduced, and financial records demonstrating that the business activity has been reduced. Now I'll turn it back to Richard to discuss documentation.
Thank you. So in connection with your submission of your loan forgiveness application to your lender, you'll also be asked to submit some supporting documentation, including bank account statements or third-party payroll service provider reports documenting the amount of cash compensation paid to employees, tax forms, or again, equivalent third-party payroll service provider reports for periods overlapping with the covered period, payment receipts, canceled checks, or account statements documenting the amount of any employer contributions to employee health insurance and retirement plans. You'll be asked to show documentation showing the average number of FTE employees on payroll per month employed during the relevant reference period. And for non-payroll costs, you'll be asked to show documentation verifying the existence of the obligations or services, again, under leases, mortgage, or utility agreements prior to February 15th, 2020, and eligible payments during the covered period. For mortgage interest, lender amortization schedule and receipts or canceled checks, verifying the eligible payments. For rent or lease payments, copy of the current lease agreement and receipts or canceled checks, verifying the eligible payments. Next slide, please. You should also maintain documentation after you submit your PPP loan forgiveness application, including the PPP Schedule A worksheet that you use to determine any salary wage reductions or FTE reductions, or why those are not applicable, and documents supporting the listing of each employee listed on PPP Schedule A worksheet and their respective 2019 salaries, documentation regarding any employee job offers and refusals, firings for cause, voluntary resignations, and written requests by any employee for reductions in the work schedule, again, related to these FTE reduction calculations, your actual FTE reduction calculations, and all other records relating to the PPP loan. You should keep all this documentation for at least 6 years after the loan is forgiven or repaid, whichever is later. And the SBA has the right to audit and review these documents on request. The SBA has indicated they will review all loans over $2 million, but they also reserve the right to review any loan of any amount, including any request for forgiveness. The SBA will notify borrowers in writing if your application is under SBA review, and borrowers will have an opportunity to respond. Next slide, please. And that concludes our formal presentation. Thank you very much for your time and attention.